This week on the Communicators, two perspectives on Senate legislation that would make changes to patent law. The Senate Judiciary Committee is expected to vote on the bill in the next week. Joining us to discuss how potential changes could affect the technology industry are Taraneh Maghame of the firm Tessera Incorporated and Ed Black of the Computer and Communications Industry Association. This interview was recorded on March 11th.
The Senate once again is taking up patent reform, with legislation being dropped and hearings already taking place. Today on the Communicators, two perspectives, particularly from an industry viewpoint. Joining us first up to talk about it is Taraneh Maghame. She is the Vice President for Patent Policy for Tessera Incorporated. Thanks for joining us.
Thank you.
Could you give the viewers at home just a brief kind of capsule of what Tessera is all about?
Sure. We're a technology company in California, in the Bay Area, and we were founded by three former IBM technologists in 1990, and our core mission has been to develop technology in the semiconductor packaging area. Currently, our business is, for the most part, licensing that technology to others who can manufacture it, and we are also expanding into the imaging and optics area and developing new technologies in that area. So if you have a small cell phone in your pocket, you use Tessera technologies.
Just recently, you appeared before the Senate Judiciary Committee to talk about the issue of patent reform. What message did you have to deliver?
We are urging caution with patent reform because the current bill has the potential of damaging innovation in this country, and we're very concerned about that, particularly in light of the current economic situation.
If you had to boil down your concerns, what would be chief among them?
Our primary concern has by far been the damages provision that's in this bill.
Joining us to help in the questioning is Roy Mark. He's with eweek.com. He's their Washington Bureau Chief. Mr. Mark.
Thank you. Taraneh, Senator Leahy said yesterday at the hearing that both sides are closer to reaching consensus on this issue than they ever have before, and they've been debating this for a number of years in Congress. Twice before, it's been defeated in the last two Congresses. And yet Senator Feinstein says that's not true at all, that there does not appear to her to be any real reconciliation, any agreement being reached there. What's closer to the truth there?
I think there has been some movement on certain parts of the bill. I think there's been a lot of discussion about it. Obviously, it's been out there for a number of years now. And the rest of the bill is probably closer to consensus. But when you talk about the damages issue, which has been the primary sticking point, I believe that Senator Feinstein is probably more correct because the current language is exactly the same as the language that was in the bill that was in the last Congress. And there needs to be significant improvements to that language before any consensus can be reached.
Well, in the last Congress, that same language passed the House, it passed the Senate Judiciary Committee, and it was only in the Senate that it ultimately failed. Do you sense that those who are for patent reform are gaining momentum in this, that this might be their year to achieve these changes on damages?
Well, it seems that they believe that that's the case. I'm not sure that is. I mean, I really can't comment on whether they're gaining momentum at this point. What I can comment on is that a lot of other industries and groups have come out with their concerns on this particular issue. Over the last couple of years, we've had not just small technology companies like ours concerned about future innovation. We have had manufacturers that have expressed concerns about it. We've had unions that have concerns about creation and loss of jobs, basically. We've had biotech, nanotech, universities, which are big research institutions. And in fact, Senator Feinstein specifically referred to universities yesterday. So there's been a lot of concern that needs to be taken into account before any kind of consensus language can be reached.
If you could give a brief explanation when it comes to settling damages, when it comes to patents, how do courts currently do it, and what's this bill potentially changing?
Well, currently there is a case that has called Georgia Pacific, which you probably heard referred to, that has laid out 15 different factors that may be taken into account by a jury or the judge in determining what reasonable royalties should be in any given case. And of course, reasonable royalties are determined only after the patent holder proves that the patent is valid and that the patent has been infringed by the defendant. So it allows flexibility in determining what the royalty should be by using the various factors that are applicable. What the current language does and what the proponents of this language have been trying to do is introduce what we have from day one called an apportionment-based calculation, which basically requires that any product that's found to be infringing be apportioned into various components, and then the value of a specific component that the patent relates to be determined first before you move on to the royalty calculation. And we believe that that aspect is already taken into account in the 15 factors that the courts may consider, and this new formulation introduces very rigid parameters which will artificially reduce the value of patents.
So for small firms like yours, can you give a practical application of what that means and how that plays out in a court situation?
Well, I can refer to our particular technology. For example, our core technology is the packaging of semiconductor chips. Now, it's hard for me to determine how you apportion that into a component. Do you take the value of the chip? Do you take the value of the parts that go into the packaging? Do you take the value of the full product that the package goes into? Because our packaging is what, for example, has enabled the big brick phones to be made into small phones that fit into our pockets. So you really can't focus just on one component. You need to take the overall aspect of the commercial success of the product, the relationship of the licensee and licensor, and various other factors that are laid out by the courts.
So if this new rule came into place, I would look at that phone as far as a violation and say, not the phone as a whole, but the one tiny chip in there is what I'm specifically looking at as far as how I'm going to award damages.
Possibly, but a very simple example also that has been used is the Post-it note. I'm sure you've heard about that because paper was nothing new, glue was nothing new, but when glue and paper was combined to create the Post-it note, how do you apportion the value of that contribution? Now, there is another rule that is called the entire market value rule that also allows, in certain circumstances, for the entire market value of the product to be taken into account when damages are being assessed. But again, royalty is going to be based on a percentage of whatever value there is. So it's not as if you get the whole amount.
Yesterday, you essentially said the high-tech industry has been playing fast and loose with its numbers about exorbitant jury awards. And in particular, there was a case 2 years ago, I believe in 2007, where Alcatel-Lucent won $1.5 billion judgment on Microsoft. You introduced some numbers yesterday. Would you like to discuss those a little bit about the number of cases and judgments?
Well, the main point I was trying to make is that there really has not been any exorbitant damages awards per se. The $1.5 billion award that you referred to was actually reversed by the judge, the trial judge, not even on appeal, but the trial judge recognized that the jury instructions did not, or the evidence did not support that award. And there was an issue with the jury instructions that had been given. And that is why the gatekeeper provision that Senator Feinstein referred to yesterday makes a lot of sense in the sense that judges can be giving better instructions to the jury as to what they should and should not consider. Now, in terms of the studies I was referring to, if you look at the past 4 or 5 years and all of the awards that have been issued in patent cases that have gone all the way through trial, the median damages award has been $5 million. And then if you look at all of the patent cases, including the ones where no damages was awarded, the median drops to $2 million.
You also suggested yesterday that instead of passing this bill, or at least the damages portion of this bill, that Congress should wait to see how the courts ultimately rule on this Alcatel-Lucent case. Do you have any sense of when the courts might hear that case?
Well, the case that we were referring to in terms of of Congress waiting for the result is a different case than the one that you referred to. I just want to clarify
Okay.
that because there were different parts of this case. The case that is pending right now is on appeal to the Federal Circuit, and it is going to be heard in early May, I believe. It's been scheduled to be heard in early May. And that will not necessarily resolve all the issues that have been brought up with respect to damages, but it'll certainly provide more of a guidance as to where damages law might be going. But also, the main issue, I think, is that the courts have been addressing a lot of these concerns that have been brought up over the last few years. In fact, the reason for the hearing yesterday and the title of the hearing was particularly the case law that has developed. And the courts have, for the most part, addressed pretty much all the concerns and will continue to address those concerns. So now legislative action is basically not necessary to deal with injunction issues and venue issues and various other things that have already been addressed. This Lucent case that's on appeal is another example of one where the courts will, to some extent, address parts of this issue.
Would you support patent reform if it did not have the damage portions in there, that all the other really sort of esoteric issues involving patent reform, first to file, that sort of thing? Are both sides pretty well in agreement?
We support patent reform to the extent that it strengthens the Patent Office and strengthens the quality of patents. I'm not going to comment on the word-for-word language of the bill as it is right now, but what I can say is that we're not against patent reform. We are for patent reform, but we're not for patent reform that's going to damage our system, and that's been our main concern. We think there are good parts of this bill that we could support, but the parts that are bad for our economy and our innovation system far outweigh what's good in it right now.
So really, in a nutshell, you oppose the damages, the proportionment of damages that's being suggested by the high-tech industry.
That's our primary issue. We have had issues, and we continue to have some issues with the post-grant opposition language that's in there that could create more avenues to attack patents and create delays and various other problems. And there's a couple of other minor issues in there that we've also expressed concern about. But I think the focus right now is on the damages part because that's really the thing that needs to be fixed.
Who is your lobbyist, so to speak, here in D.C.? Who talks to legislators and the type for companies like yours?
Well, we've actually formed a group to work on this issue, and Tessera is a co-founder of the group. It's called the Innovation Alliance, and we are a group of companies who are primarily in the business of developing technology and licensing that technology to others who are better able to manufacture it. Tessera's consultant is Manus Cooney from Potomac Council, but the group as a whole is working with a number of different folks on the Hill to make sure that our message is heard.
Several senators, including Senator Brownback, Senator Coburn, Kip Bond, have sent a letter urging Senator Leahy to kind of go slow approach on this. What do you think that means as far as their concerns? I think they're all Republicans and Democrats on that list too.
That's correct, and we are grateful that that letter has been sent because we agree that there needs to be caution taken in moving forward on this bill.
Quickly, you had said that you support the aspects of the bill that strengthen the Patent Office. If that's the case, are there weaknesses in the Patent Office?
The Patent Office currently does not have enough resources to handle the number of applications that it has. And currently with the economic situation, we understand that it is under an even more financial burden, and there are even more difficulties to address the number of applications. And if we cannot superfund the Patent Office, which is the term that we at Tessera like to use, and allow them all the resources that they need to make sure that quality patents come out of that office, this problem is not going to be fixed. So that's what we should be looking to, fixing the Patent Office such that we get quality patents out of the office and not trying to fix it through litigation reform, which is where most of this bill is addressed to.
What kind of figure involves a superfund in your mind?
It's hard for me to tell. I don't know enough about the workings of the Patent Office. What I do know is that it's a very important component of our economy, and if we want to avoid, shipping our IP to foreign countries and losing jobs, we need to make sure that that part works well. And to the extent that they need the funding, we need to make sure that they get it. There's been diversion of funds from the Patent Office over the last several years. The last 2 or 3 years, I think they've been able to keep all the funds. But of course, there's going to be a drop in those funds as well, because applications are going to drop in light of the economy and companies cutting back. So it makes it even more important to ensure that they get appropriate resources.
We have time for one more question.
Another example, you used the Post-it note. Another example that's frequently used in this debate is the issue of a windshield wiper. And if an infringement is found, should the value be based on the value of that windshield wiper to the car, or, as your organization suggests, it should be the entire value of the car?
I don't think our organization is suggesting that it should be entire value of the car, in no way or form. What we're suggesting is that a number of factors need to be taken into account to determine what is a reasonable royalty in any particular circumstance. What I would ask is there a situation where for windshield wipers, royalty has been based on the entire value of the car? I know people are very fond of using that example, but I certainly can't remember any situation where a whole car has been used as a basis for royalty on windshield wipers. So it, to some extent, bothers me that that example keeps getting used, because it is not a real example, just like the basis and the fears that that companies have expressed regarding extraordinarily large damages doesn't appear to be based on any real cases.
Ms. Maghame serves as the Vice President for Patent Policy for Tessera Incorporated. Thanks for your time.
Thank you.
We continue our conversation with Ed Black. He is the President and CEO of the Computer and Communications Industry Association. Who do you represent?
A wide range of companies, computer, telecom, internet companies, small, medium, and large. Basically, we've been around for about 40 years, and we're really came into being to provide the competitive component of making the innovation economy work. So we've been very involved in making sure there's openness and competition and access to wide range of companies.
Is there a relation between being competitive and the topic at hand as far as patent damages are concerned?
Very, very much so. I think it's worth stepping back into what is the purpose of the patent system, and it really is to provide an incentive for innovation, creativity. But when you do that, you take away certain rights. You take away the ability to compete in the free market because you're giving somebody a limited monopoly. That's a powerful tool to give to somebody. That is considered an anti-competitive tool. It's one we're willing to do because we think giving it in a limited way provides some extra incentive. You're also taking something out of the world of, if you will, free speech, free flow of information. The ability to communicate and talk about things. So you're drawing from two very valuable areas that we think are important, the open market and the open free speech market, and you're saying we're going to take some rights from those areas from people, and because we're convinced that there needs to be a little extra incentive for really creative, unique ideas. And so we've done that. But in doing so, we've got to make sure, since we're taking something very valuable, that we structure what we're doing in an effective way. So what we're doing is want to make sure that the goal of creating new, innovative products to help the public works efficiently. And so what we have is, therefore, a negative impact on competition that has to be justified on an ongoing basis, that is providing an equal sufficient amount of unique innovation that wouldn't otherwise happen. And so it's very important that when you're giving somebody a monopoly, you're really cutting off a lot of people from getting into that space. And it goes back, one of the core issues in this legislation is patent quality. Because if you wind up giving patents on stuff which is common, which really isn't that unique, which really doesn't deserve a patent, you're shutting a much wider group of players out of the marketplace.
Mr. Mark.
Ed, you mentioned that the quality of patent was important, but I think essentially most people are saying the only real differences left between the high-tech industry and manufacturing and pharmaceutical is the question of damages. Now, the mainline traditional manufacturers, pharmaceutical industries like the system the way it is. Tech has fought this for a long time. Could you explain a little bit about how the damages work and how you think the industry, or why they ought to change how damages are apportioned?
Certainly, but let me again root it back to what I said, because if we had a system that had a fraction of the patents we now have, And all of those patents, when granted, really were solid, really represented something, unique that we all could agree, wow, this is important. A lot of the other issues down the road would disappear because it is the questionable patents and the quantity of those that make any legal system we have a much wider impact on many, many more companies, many, many more players, and on the economy. So if you screw it up at the outset, the repercussions keep multiplying out. And so if you really had good, solid patents, how you portion damages might not be quite as important. I mean, would be definitely not be as important. Because if you've got a patent that really critical, which is the key thing that makes something important work, and without it, no way, it would be easier to be flexible on how you calculate the importance of that. But so many patents are weak and vulnerable. If you give the power to the patent holder of a weak patent, the huge legal power with huge damages being a part of that, we've talked about injunction capability, but the more power you give to a patent holder, it's great if that patent's really solid. We want that patent holder to have real power. But the real world right now is we have hundreds of thousands, if not millions, of patents that are either bad or very questionable, and in some cases very broad, and so could apply to a wide range of products. So all of a sudden you put at risk of tremendous liability, possible extortion, at huge dollar figures, a wide range of players. And that's the problem. It is the risk. You could have many companies because of the damage structure, small companies, but definitely even billion-dollar companies, who in essence could have their existence threatened because there's some fairly minor patent that is then used to threaten them. I mean, RIM had a $650 million patent that they case against them on patents that were in the process of being invalidated. But that process took forever. It took so long. Their stockholders, their users were all worried and troubled during that process. So the power to those people holding what turned out to be some invalid patents was so powerful legally that in essence it made a company that wasn't violating patents settle at a $650 million level. That just doesn't make sense.
So how would tech do it differently?
Well, I think
given that there are weak patents out there, and there's going to be litigation, and there's going to be judgments.
Well, there are other provisions that I think are important to be part of the law in terms of review, subsequent review, and some of those were compromised so that there's now less, after review in order to deal with, frankly, the smaller, innovative type companies, because we very much want to make sure that the system does work for the small guy as well as some of the larger companies.
So how would your damage sort of formula work differently than what's currently being used in the court?
Well, what's currently being used does allow, I mean, I heard some earlier discussion about windshield wiper, might use something about a wheel on a 737 if you really want to magnify that differential. The idea that somebody has I guess it's worth explaining the difference in structure between tech industry and pharma. Okay. A drug will have a formula which becomes the subject of patent. And that formula, that patented thing, is really pretty much the totality of the product. There's not a lot of other things. There's not tons of other pieces. In a computer, just a laptop, you could have, you first have a lot of hardware components and a lot of software components in the thousands, okay? So you've got all kinds of components, some of which are very small, some of which are large, but even one component can sometimes be the subject of hundreds of patents. So you multiply thousands of components by, let's just say, a couple patents each, and you've got a lot of overlapping claims of patents. Now, because when I say they're affected by patent, doesn't mean those are valid claims. It means there's somebody out there saying there's a risk. So if you start saying that, therefore, any one of those components can get a damage award, in essence equivalent to the value of the computer or very accentuated, in one particular instance, there might be some sense to that, okay, if it's a really critical component of the computer. But you've got lots of components, lots of claims, and so if all of those people are in essence in the position that they can say we want to extract large value, more than just the reasonable value of our component, you could wind up having claims that far exceed the value of the product itself in totality if everybody came at them at once. That's not an economic model that works. And where we actually focus very heavily on it, what it does is it disincentivizes a lot of innovation. And a lot of companies are spending a substantial amount of their money, I won't say putting phony patents, but paper patenting. Every little invention they do, they're going to make sure it's covered by lots of patents so that they can protect themselves if somebody comes after them. That's a huge waste of resources and energy. And because those take engineers, those take people who otherwise would be creating new products and more creative products.
Has there ever been hard data compiled about damages or excessive damages when it does specifically deal with certain amounts of patent violation? I think one of the points that came up yesterday that maybe some of the things were more anecdotal than anything else rather than hard data that was compiled.
Well, I don't have there is data out there. I don't have a lot of it with me. Numbers at some point fade, but I will say I've got a number here, I think, in terms of the value of awards, okay, and I think the settlement process is worth talking about, settlement versus real litigation. But when you look at going back to 1991, the average damage award was at less than $1,600. It's now, in 2005, even a few years ago, had gone up to $6,000. So from 1,600 to 6,000. So you've seen an escalation as people learn how to game the system better and better. You get into those numbers. And I think it's worth pointing out that we're talking here, when we're talking about damages, we're talking litigation process. The number of cases that are settled prior to going to court is the huge bulk. But it is, and they often settle because companies said, why risk these potentially huge damage awards based on this calculation that others would like to use and claim the current system? It's easier to settle. So you have many, many companies settling just as nuisance settlements, but they're not insignificant amounts of money.
Is this, we've talked a little bit at the earlier part of this show about this issue, and this bill has come down several times. Is there a difference this year in your mind as far as actually getting it passed?
I do think there is. I think I actually like the bill that was passed last year better than some of the compromises made here, but there's still a lot of merit to this bill. This has been going on for at least 6 or 7 years as a major piece of legislation. I would hope that a couple things have changed. One, the pharmaceutical industry, frankly, had a lot of close connections with a lot of the Republican senators, and the ability in the Senate to get 60 votes to pass something was always a key measure. There was a solid block against that. I think some of those ties are weakened. There's fewer there, so I think there's more of a political ability at that level. I also think that the recognition that this is a problem that needs solving, it's not going to go away, it's going to keep coming back, has incentivized some people to work for more pragmatic compromises. Having said that, and I think there's an awful lot of people willing to look for a compromise. I think there are people on the edges who are not, and that always makes prospect for passage less serious. But you do have a bill, you have the congressional leadership in both House and Senate say they want to do this. I think you have to assume that therefore getting it passed is a very viable possibility.
Senator Feinstein recently said that, and I quote, "High tech seems to feel they're going to get whatever they want out of this bill." You've never been able to get this bill through Congress. Are you that confident this time around?
No, not at all. I mean, I think it's not we want what we want. We think we understand how our industry works, and we know that this is harming the industry in an illegitimate way. This is not a greedy tax break. This is something we're saying. This is causing irrational outcomes. It violates common sense when you really look closely how it operates. We don't think it's asking too much to say, make this system work in a common sense, reasonable way. Having said that, we understand there are political forces and players, and we've got to work with it. I think at the end of the day, our goal isn't to pass a piece of legislation. Our goal is to fix a broken, screwed up system and make it work at least a good bit better. So I certainly don't want perfection. I don't expect it. I think we're going to probably get something, if we get something passed, it will not meet all the problems totally effectively. But hopefully it takes some of the worst aspects of a system which really has gone astray, out of the game. I think it's just maybe worth mentioning a few of the parts. I know it's not the damages per se, but when a patent system provides a patent for yoga positions, for tax preparation strategies, for movie plots, for a peanut butter and jelly sandwich, and even for method of how you swing on a swing. I mean, you've got to say, if nothing else, that shows there was something wrong in the patent system. Now that goes to the quality issue and its business method patents. But those also can come into play in our world.
We've got about a minute left. I think a lot of factors, people in this discussion agree that changes at the patent office are needed. In your mind, what is it going to take to make for those stronger patents in the end? At the patent office, what needs to be done there?
A lot. We have proposed certain reforms in that area, certainly having outside expert reviews, if you will, open sourcing some experimentally. We think a great amount of it is the culture. There are a number of quotes I could dig out where basically people equated innovation with number of patents. Well, that's not the case. And you've also got a percentage of patent applications approved that are at the 90% level. I don't think you can get driver's license issuing at 90% level. These are people coming in asking for a massive amount of authorization and legal power to be bestowed upon them, and only 10% are not valid. No, I'm sorry. You're talking hundreds of thousands, millions of patents over the last couple of years. Really good ideas, are important, and we really want to protect. But that many patents, I don't think so. So I think when you ask about fixing the system, you need you change the incentives on the patent examiners and process. You don't just award them for how many patents they do, and I know that's not accurate per se, but really there was a culture that the more patents you got through, that was you were doing good. You were good customer service. The customer of the patent office should not be the patent applicant. The customer is the American public interest, and therefore bad patents are as damaging to our society as not issuing a good patent.
Ed Black is the president and CEO of the Computer and Communications Industry Association. We want to thank Roy Mark of eweek.com, their Washington bureau chief. And we also want to thank earlier from this program, Taraneh Maghame of Tessera Incorporated. Thanks for being on.
Thank you very much.
Tomorrow on